I'm here to talk about estate taxes and some estate planning issues. And essentially, when we talk about estate planning, really what we're talking about is making sure that our assets pass down to the next generation or down to our beneficiaries in a manner that's both tax efficient and administratively efficient, so that there's as little cost as possible, hopefully, to your heirs at the time that you pass away. So unfortunately, estate tax is a little bit of a dry subject, so I apologize. I'll try and make it as exciting as possible for you, although I don't know that that's possible. But what I wanted to start off with, I hope, is maybe just a little primer for estate planning purposes. And as I mentioned, one of the things that a lot of our clients are concerned most with are estate tax issues. And there's been a lot of changes in estate taxes recently, and we'll get into some of those changes as well. But I wanted to give us a little primer as to what we consider as assets that are part of your estate for tax purposes, or what I should say the taxing authorities consider as assets as part of your estate for estate tax purposes. So when you pass away, obviously the value of your assets at the time that you pass away are what the taxing authorities considered as your assets at the time that you pass away. And these are the assets essentially that they're talking about when you pass away, the value of these assets. Any real estate investments, obviously, that you own at the time that you pass away are going to be considered part of your taxable estate. Real estate includes any real estate that you have an ownership interest, net of any mortgage or other liabilities on that property. All right, so only the equity in real estate that you hold at the time that you pass away is included in your estate for tax purposes. Any investment, stocks, bonds, mutual funds, any cash in the banks, all part of your estate for estate tax purposes. Any retirement plans, 401ks, IRAs, Roth IRAs, all part of your estate for tax purposes as long as you're the owner of that account. Any small business interest that you may own, the value of that business interest is in part of your estate when you pass away. The IRS requires that you value that business interest at the time you pass away, and that asset is part of what they consider your tax base. Life insurance, I specifically mention that because that is something that a lot of people do not consider part of their asset pool, at least while they're alive. Obviously, it's a benefit provided at the time that you pass away, so you don't consider it an asset that you benefit from during your lifetime. But at the time you pass away, the full death benefit of any life insurance policy is going to be part of your estate for tax purposes. All right? And that includes whether or not the policy is a policy that you privately own or whether it's a policy provided through your employer. All right? So if anybody has a group life insurance policy, the death benefit that's paid by that group life insurance company is going to be part of your estate for tax purposes. I also thought it was important, and feel free, if anybody has questions, feel free to interrupt me and ask any questions as we go along here. I also thought it was important to talk about how your assets are going to pass at your death. All right? There are three essentially basic ways that assets can pass at the time that you pass away. And the first one is by contract. And what we mean by contract is essentially beneficiary designation. So at the time that you establish any type of IRA, 401k, any retirement plan, life insurance, or annuity, you have a contract that you've executed with that financial institution that not only provides for the actual investment that you are making with that financial institution, but you are also agreeing with them to name the person who is going to receive those assets at the time that you pass away, i.e. a beneficiary designation. So if you look at any of those contracts that you may have executed, there always is a beneficiary section that requires that you name the beneficiary and you establish to that financial institution who the person is to receive any benefit from those assets at the time that you pass away. So it's important, if you have any type of asset that has a beneficiary designation, like an IRA, 401k, or a life insurance policy, that you review the beneficiary designation of that financial asset to make sure that the beneficiary is the person you want it to be. I don't want to bore you with any war stories, but I can tell you that on at least 10 different occasions in my 15 years of practicing, I have had clients come in after a loved one has passed away, only to discover that one of these types of assets is passing to a beneficiary that the decedent did not intend. Usually it's a group life insurance policy that was provided through an employer that they either lost the paperwork to change the beneficiary or they just forgot to change the beneficiary. So I can't stress how important it is to make sure that you look at any beneficiary designation that you may have executed in the past. The second way, one last thing with respect to that, and I'll talk about that in the will, is that even if you have a life insurance policy and in your will you say, I want the benefits of that life insurance policy to pass to Tim Dengler, all right? It is overridden by the beneficiary designation that's on file with the financial institution. So having it specifically mentioned in your will not override the beneficiary designation of that financial company. Operation of law is another way that assets can pass at the time that you pass away. And essentially what we're referring to here are jointly held assets. All right? So any asset that you own jointly with somebody else that has a designation either as husband and wife or jointly with rights of survivorship is going to pass 100% to the surviving joint owner. So if you own your home or any real estate jointly with your spouse, they will receive your interest in that property automatically at your death. If you own joint property, bank accounts, or any other type of property with anyone other than your spouse and it designates with rights of survivorship or WROS, 100% of those assets will pass to that surviving beneficiary. So again, it's important to look at the titling of any assets to make sure that any assets that you want to pass under your will do not have a designation of with rights of survivorship on them. And then the last way and the most common way that assets will pass is your will, all right? And a will, contrary to popular belief, is a very, very simple document to prepare and execute, all right? Depending upon your circumstances, a will can be very, very simply drawn and basically is just a statement of how you want your assets to pass at the time that you pass away. Having a will in place will allow your heirs to pass your assets and minimize the costs associated of passing those assets as opposed to not having a will, all right?